Yeah.
All right. Thanks everyone for joining today. We're looking, really at do your documents still protect you? For a lot of people, once they've done their estate planning, that box is checked, it's off their to-do list, and they don't think anymore about updating their documents. So I really encourage you, if you already have estate planning documents, pull them out and take a look. When were they executed? We really recommend to clients that you review your documents every 3 years at a minimum, or if you have a major life change, such as a birth, a death in the family, a diagnosis of some sort, a marriage, divorce. Sometimes when we review documents with clients, there really are no changes needed. Other times, clients call and they say they have one tiny little change to make, and then when we actually go through and review the documents, we realize there's actually a lot of changes that are needed. So you really need to, make sure that your documents reflect your current situation and current wishes. Otherwise, they won't do what you want them to do. One of the biggest estate planning myths is truly once your documents are done, they're good forever. I often see people who, the first set of estate planning documents they got done was when their kids were really little, and their priority was making sure they had a guardian in place if something happened to them. Then I see the same people, when they come back 20, 30, even 40 years down the road, their kids are grown, they look at their documents, and they're at a completely different point in their lives than they were when the documents were first prepared. Um, when we're looking at them, they often realize like the documents really don't fit anymore. There's been life changes, sometimes there's law changes, relationships change. Maybe you name someone who was a friend or a big part of your life 20 years ago, and then that person doesn't really make sense to be a fiduciary in your documents. Also, as people get older, their financial situations change, their health changes. So when someone first gets a will and their focus is on their minor children, but as those children grow up and become adults, it's a completely different set of concerns. So that is a very typical situation for us that we see documents that are 20, 30, 40 years old, and now it's just really time to update it. I hope by coming to the presentation today, you wouldn't let your documents get to be decades old, but we do see that, and it's better late than never that we update them. Estate planning truly is not one and done. It's just like when you go get a physical with your doctor, you don't get a clean bill of health one time and then never go back. So I understand for a lot of people, it's stressful to do their estate planning. It's not fun, but you really can't do it once and then just put it in a drawer and never look at it again. You must continue to review the documents and still make sure they work with your life. When your documents become outdated, sometimes people think, well, what's the worst that could happen? I have my documents, but what's the worst that could happen if they're outdated? Well, first of all, you could have the wrong people making decisions for you. So if you have someone appointed who's a friend or a family member that you're no longer close with, they could be in a fiduciary role. The other situation we see is you have a family member appointed as a fiduciary, fiduciary, and that family member has their own health problems. I recently had a situation where the executor was in memory care, couldn't serve, and it was just another hurdle to go through to get a medical renunciation. So, a lot of times things can be dealt with, but it's just making it more difficult for your family members or loved ones. And most people, by doing your documents, you're trying to make it as simple as possible when you pass away. Or when your children are grown, a lot of times people want their children to step into the fiduciary roles. If you did your documents when they were minors, they're not listed as executor, power of attorney, but oftentimes people want to replace family members or aging friends with adult children. The other issue when you have an outdated document is a delay during emergencies. This is kind of goes off of what I just said about the situation where the woman, the executor had dementia. So it was just another hurdle for us to get over. The same thing if someone in your document has passed away or is unable to serve. It just makes it an already difficult situation more difficult if you don't have the correct fiduciaries in place. If your documents are outdated, there's also a higher chance of family disagreement and conflict because your documents don't reflect your current wishes or the current family situation. When there is a conflict between family members, there's a higher chance of court involvement, which is always worst case scenario. We never want the court to have to get involved. We want documents that are clear, that reflect your current situation, so that once you pass away, things can, go seamlessly. Another issue we see often is a power of attorney document that doesn't reflect the current law. So the law changed in Pennsylvania in 2015. If you have a power of attorney document that was valid, that was executed prior to 2015 and was valid when it was executed, it is still valid. The law didn't make a prior document that was valid at creation invalid. However, it's very difficult, just in the first place, to have banks that are willing to, accept a power of attorney. They have to kick it up to legal. So if you're going in with a document that doesn't match the current law, it just is even more difficult. The banks will really resist accepting that document. So if your document's older than 2015, absolutely you should think about updating that. And then with healthcare providers, they will also oftentimes question the authority of your fiduciary on an outdated document. So this all goes back to when you do your documents, most people just, a big reason why you're doing that is to make it easier on your family and friends. Outdated documents don't do that. They make it hard, they make it difficult. So it's really, even though it's not a fun thing to do, it should be a priority to make sure your documents are current. The documents that you really need include a general durable power of attorney, a healthcare power of attorney and living will, a last will and testament, and or a trust, depending on the situation, and then beneficiary designations on accounts that are controlled by beneficiaries. So those are accounts that don't pass by the will, so like life insurance, retirement accounts, annuities. The general durable power of attorney is they're all important, but it's so critical that you have a power of attorney document. This document would appoint someone who you trust, who can handle your finances, step in, pay your bills. Um, it's also important not only that it's someone you trust, but that's also actually able to handle the job of being a power of attorney. I talk to people who have 3 kids, they're all equally trustworthy, but then, the parent says, this person hates to deal with finances or hates to deal with banking or hates paperwork. So those are just things to think about when you're naming your power of attorney, who could actually step in and handle the job. Um, your healthcare, actually, let me go back to power of attorney for just a second. The other reason it's so critical is that if you don't appoint someone as power of attorney and you don't have a document, and let's say something happens and you actually become incapacitated, so you're not able to execute a power of attorney document, you're leaving your family in the situation where they would actually have to get a guardianship over you, which is truly, again, court involvement, worst case scenario. We really do not want people to have a guardianship. You lose all of your rights. And so it's better that while you have capacity, that you appoint your decision makers, who you would want to help you in those situations. All right, now to the healthcare power of attorney. The healthcare power of attorney is a document that names someone to make healthcare decisions for you only if you are unable to make your own healthcare decisions. If you don't have a healthcare power of attorney, Pennsylvania law establishes a strict ordered list of who is authorized to make medical decisions. So that is Act 169. So there is a fallback. The problem is the list often isn't who you would want, or you might have multiple decision makers in the same class that don't get along and that, could cause issues if they're trying to make decisions together. I've also had a situation where a parent wanted a child to serve as healthcare agent, but then when they actually sat down and talked about it, the child specifically said, I would not be able to follow your wishes because it goes so strongly against what I believe. So if you are leaving it up to the law and who would be the decision makers, you're not you're not making the decision and you're not choosing someone who actually would follow what you want to have happen. So it's really important that you make sure if you already have this document that the people listed are still who you would want to make medical decisions for you if you're not able to make them yourself. In conjunction with the healthcare power of attorney is a living will advance directive. It's a legal document that specifies medical treatments that you would or would not want if you are end stage and unable to make those decisions for yourself. It's a broad directive for future non-emergency care. I think that this document is helpful so that you're not leaving the burden on your loved ones to try and guess what you would want. It's right there in black and white. Even if in the document you say, this is guidance, and ultimately you're leaving it up to your healthcare agent to make the final decisions. Still, it's better than not having anything and not having any guidance for your agents. I just think that that puts a huge burden on your loved ones to try and make those decisions for you without any kind of documentation. And then, of course, everyone should have a last will and testament. Um, no matter what, even if you're like, well, I don't have that much, or I have a joint account, or whatever, you should still always have a last will and testament. This is the document that specifies where your probate assets will go when you pass away. If you don't have one, or if you did your documents a long time ago, you should look at it and confirm that it still makes sense for your family situation and current goals. Sometimes people bring up trust. We can use trust sometimes as a will substitute. There's different types of trust that serve different purposes, but very generally speaking, trust can help with asset management. It can avoid probate, although in Pennsylvania, probate's not that big of a deal, so we wouldn't, want to let the tail wag the dog in terms of just trying to avoid probate. But sometimes that is one effect of having a trust. They can help with long-term care planning, protecting beneficiaries, and special needs planning. Not everyone needs a trust. It really is so situation specific and it doesn't fit everyone. So I have clients all the time who come in thinking they need a trust, and we sit down and we talk about their specific situation, and they say, well, my neighbor's sister's friend said they did this, so I should do this. And you really have to look specifically at your situation, what your goals are. And a lot of times, they actually don't need a trust and we have a different plan. So it just depends on everyone's situation. Beneficiary designations are usually the most overlooked part of estate planning. So people do their wills and think, okay, we're covered, we've dealt with everything. The problem is there are significant assets that pass outside of the will, one being retirement accounts. I mean, a lot of people's wealth is held in retirement accounts that pass by beneficiary designation. So we really need to look at all of the assets holistically and determine which assets pass by the will and which assets pass by beneficiary designations. The problem we see sometimes is we have a will where you've taken the time to set up your documents so that your intention is so that everything to your child goes in a trust, but then the beneficiary designation on the retirement account just has your child listed outright. So it is important that the beneficiary designations and the will work together to have, so there's a cohesive plan. So all of the assets are passing how you want them to pass. If one thing is outdated, if fiduciaries in your retire or fiduciaries in your will or fiduciaries on the power of attorney, if those things are outdated, the entire plan can be affected. So when we meet with people to look at their documents, we look at all of their documents, even though usually people come in and say, I just want to make one change in the will. Well, if you're doing that, then we might as well review everything and make sure it all makes sense together. I already touched on this a little bit, but when should you review your estate plan? It's any major life change, such as marriage, divorce, births, growing families, death of anyone named in the documents, whether as a fiduciary or a beneficiary. Also, we recommend if you're moving to another state, documents are valid in the state where they're created or valid in any of the 50 states. However, there are other different considerations that should be taken into account if you move. For example, Pennsylvania has inheritance tax. Not all states do. Actually, most states do not have inheritance tax. We're one of the, I think maybe like 12 or 10 states that still have it. So if you move to another state, you should definitely have your documents reviewed by a lawyer in that state and potentially updated. And obviously, if there's significant health changes, you should look at the estate plan. We usually, if there's a significant health issue, we do often have to update asset titling or the wills or, update fiduciaries as well. Do we have any, pause for a second, do we have any questions about anything at this point?
We don't have any questions yet.
Okay, perfect. All right, I'm gonna go to the next slide. So we have, this is a situation we see frequently. The documents were signed 20 years ago. The primary agent is deceased. The backup agent is unavailable. There's family disagreements about who's going to serve, what's going to happen. The result is just a lot of stress, confusion, delays, anger, family issues. Um, so the documents really need to be reviewed. Also, when we have a situation where documents were signed a long time ago and there is a diagnosis, a lot of times when people are first diagnosed with a health issue, they still have capacity. It's not instantaneous where people no longer have capacity to update documents. But if you wait too long, it's possible they will lose that capacity. So time is of the essence because you never know when something like that is going to happen. I have a client who, they just thought they'd get around to it. There were no concerns. They were joint on most accounts, but obviously not retirement accounts. And the husband had a medical situation where he became completely incapacitated, wasn't able to execute documents, and then they had to do a guardianship. So again, then you have court involvement with every area of the finances, and it's just much more difficult than if the power of attorney had been done. The next case study um, is something, again, something else we see often. The power of attorney signed decades ago, and a power of attorney that is signed when someone is 30 or 40 might be different than a power of attorney that is signed, with someone who's in their 70s or 80s, or we're looking at potential long-term care options, Medicaid planning. Um, so we see that where we have a power of attorney document where the authority in it is insufficient for us to do our work, where we might not be able to do Medicaid planning, we might not be able to do the asset production work that we want to do. Obviously, if the principal has capacity, we could just have them sign a new document. But if not, and we have seen this, the principal doesn't have capacity, and we're stuck with an outdated document that just doesn't work in all the situations that we need it to. And again, I've said this a bunch of times, but if you don't have a power of attorney and we get to the point where guardianship is the only option, it's really worst case scenario. So I keep saying this, but I want to hammer this home is review your documents every 3 to 5 years or after any major life event. When you're doing that, the questions to ask yourself when you're looking at them, I mean, we help people review their documents if they choose to. When we have an appointment, we go over everything. But if you're looking at your documents, look at all the fiduciaries, the executors, the power of attorney, the healthcare power of attorney, and ask, are my decision makers still appropriate? Or have my relationships changed? If the relationships haven't changed, is there someone else that you would want to make a co-agent or put ahead of the decision makers that are currently there? Maybe not remove them, but maybe the order is not exactly what you would want. Um, have your assets changed? So just oftentimes you don't need to change your will because you have a new asset, but if you have a new retirement account and the beneficiaries are not correct, or there's new life insurance policies, or there's titling, you have a house that's jointly owned with your spouse and your spouse passes away. Those are just all things to look at so you understand how will all of the assets pass when you pass away. Again, you're checking your documents and have you moved? Are you in a different state where you should have an attorney look at your documents? Has your health changed? And then finally, are the documents more than 5 years old? If the answer is yes to any of those questions, this doesn't necessarily mean you have to update them, but it does mean that you should probably talk to a lawyer, get your documents reviewed, and just make sure you understand the effects of having these documents in place and the updates that would be recommended. By taking the time to review the documents and making sure they're updated, you're ensuring that they're clear so that your family understands and knows what you want to have happen, which protects family harmony. It enables better decision makers because if your fiduciaries know what you want, if the documents are clear, it makes it a lot easier for them to make decisions on your behalf. Also, having the updated documents, there's protection for you if you're incapacitated. If your documents have the chain of command of decision makers who are all available and able to serve, then you know that if you become incapacitated, it's okay because you have the people there who can step in and make those decisions for you. You will truly, by looking at your documents, reviewing your documents, or updating them, really have peace of mind. The sense of relief people feel when they come in and sign their documents is palpable. Usually, people have been thinking about this for a while, and they're putting it off and putting it off. And then when it's finally done and people are leaving with their new documents or leaving after a conversation where we've reviewed the documents and they know if the documents still reflect their wishes, they truly have such a sense of relief. If you think it's time to review your documents, we're happy to help you do that. We do that, like I said, we do that frequently where it's just people are coming in for a tune-up, just want to make sure everything will still flow the way they want it to. So you can always schedule a consultation to review old documents. Sometimes no changes are needed, sometimes they are. But either way, you'll have peace of mind knowing that your documents fit your needs or you'll be on track to get your documents updated. And that's all I have. I hope that I've convinced you to pull out the documents from where you keep them. And oh, if you can't find them, that's another time to make sure your documents get updated. So I hope that you will all do that soon. Allie, any questions about anything?
Yeah, we have one question. Can existing documents be revised or must an entirely new document be executed?
It really depends on what the change is. Sometimes they can be revised. Sometimes, for a will, someone will do a codicil. It really depends on the change needed. If you're going to execute a codicil to the will, for example, and you have to go through the process of you having two witnesses and notarizing it, sometimes it makes sense to just do a new document. So then it's just all in one place. But we do sometimes just do the revisions.
Okay. Who can you appoint if you have no family members or qualified friends?
That's a great question. We see that frequently. There are companies that serve as professional fiduciaries. Of course, there's a fee for that, but there are people who can serve as executor, can serve as financial power of attorney, and you can, basically interview those people and see who you'd feel comfortable with, and then that way you have someone there who can serve in that capacity without court involvement. So again, you're still able to make the choice.
Okay, great. I think that's all the questions that we have. Thank you. All right, so thank you everybody who joined today. If you actually do have any questions that you think about or you want to follow up, we do have an email address that you can uh, send us those questions to. It's info@andersonelderlaw.com if you think about anything else. We also want to invite you to our next webinar on July 30th, so just keep an eye out for that invitation. Thanks again, everyone, and we hope you have a great rest of your afternoon and a safe 4th of July weekend. Thank you.
Thanks. Bye.